Anthony Shrine on Arch Street, my dear friend retired Justice Peter DeGangi, and my dear friend Josie Chandler, who will be testifying for me as well.
Fantastic. So your first witness is going to be my good friend also, Judge Peter Agnes.
Thank you, Councilor Kennedy and councilors. It's an honor to be here today and a pleasure to see all of you, especially to be on behalf of Attorney SallyAnn Janulevicus. I retired in April of 2020 after nearly 30 years as a judge, including 10 years in the district court, 10 years in the Superior Court, and 10 years in the appeals court. And I think I've known Attorney Janulevicus most of those years. And as I think about the state of the trial court today, I can't think of a more important moment for the trial court to have the services of competent, experienced, and professional attorneys who know how to try a case and who know how to deal with attorneys in the midst of conflict, and parties for that matter. And I think that Attorney Janulevicus meets those requirements, all A's. She has appeared before me as an attorney when I sat in the district court, both on motions and trials, maybe even in the Superior Court, I'm not certain. But I've known her well in courtroom settings and know her to be a capable attorney and, importantly, an attorney who I also know her to have distinguished herself as a lawyer by rising to the position of president of the Justinian Law Society. And some of you in this room know a fair amount about that society. I think both SallyAnn and I and many others were probably encouraged, to put it mildly, to join the society by our great and dear departed friend, Judge Joe Farino of the East Boston District Court. And as the president of a law society, I think that that is a credential that also speaks very highly of the candidate, because that's a judgment made by your peers. And so I am here to offer my unreserved support on behalf of her nomination. I think it will strengthen the district court. I think it will be applauded by the bar. I hope you approve her.
Judge, thank you very much for your comments, and it's nice to have you back here. I don't think you've been back since you retired. Councilor Devaney.
I can't stop smiling from seeing you. My only regret is that you didn't keep going to the SJC. You were there, okay? So anyway, I am so pleased, and I even brought my Justice Mass for the two great judges that I voted for, so I want you to see that. Tell me, in all the times that you saw this nominee, what was the most attribute that came through to you about her that impressed you?
I would say thorough preparation and professionalism, what stands out. You know, attorneys don't always have control over their time, as you know. Attorneys have responsibilities to clients, and as you get prepared for an event like a trial or a motion, sometimes your preparation gets interrupted by the needs of other clients who you have to be attentive to. And in some cases, that means the attorney coming into court just isn't prepared. In other cases, and I think I would put Attorney Janulevicus in this category, it means that you don't, you know, perhaps have dinner with your family that night, or you don't get to do the things after hours that most people would like to do to relax and get ready for the next day, but instead you're working into the late hours to make sure you are. So I can say with confidence that she came into court prepared, and also in her dealings with court staff, which is critical because judges don't do it alone. They can't do it alone. They work in an environment with clerks and probation officers and court officers. But in her dealing with court staff, I think she was thoroughly professional, and that's also an attribute that's essential to be a good judge.
Oh, that's great. Thank you for coming. I have seen you. You don't come to the council since we nominated you. In fact, there's two other councils here, but I'm the only one. Councilor Depalo and Councilor Kennedy didn't have the privilege of voting for you. And so I just want to say that was one of my proudest votes.
Well, I was very pleased. It's not often that you get to come here 3 times as I did, and then each time you were there as a.
3 times, yeah,
Thank you
right.
very much.
Well, thank you for serving, and I hope you're enjoying your retirement.
Trying to keep up with 12 grandchildren is itself.
It's a tough time during this pandemic for everybody, but I'll tell you, it is a tribute for you to come and be a witness for this nominee. Thank you so much.
Thank you very much.
Thank you, Judge. Appreciate you coming. The second witness isn't here yet, and if she comes late, we'll take her out of order. So we'll call on Josie Chandler. Attorney Josie Chandler.
If you have a witness that gets choked up today, it's probably going to be me. I'd like to thank the council for allowing me to speak on behalf of nominee Janulevicus. I have known Sally for over 20 years as an employer, as a mentor, as a colleague, and as a dear friend. I met Sally 21 years ago. I had just graduated college with a degree in theater, and like most starving artists, I was looking for a job. Sally was looking for a secretary, and we were introduced through a mutual friend who actually happens to be sitting right here, Judge Peter DeGangi. I recall going to see her for the first time. I was in my early 20s, I was new to the area, and I had no real idea what I wanted to do with my life, and I was initially intimidated. Walking into a big building in downtown Boston, expecting to see a high-powered attorney who would put me through my paces and then send me on my way when she realized I had no idea what I was doing. But to my great relief, that's not what happened. Sally was warm and friendly. She was straightforward and encouraging. She fostered an office environment that was collegial and supportive, and she made me feel like I was fully capable of doing whatever I set my mind to. I got the job, and I was Sally's secretary for the better part of the next 2 decades. Now, at the time, I didn't think that this would be a long-term gig. I had studied theater. I was young and unsettled, and this was my first job out of college. I just needed to pay my rent and take some time to figure things out. But as the weeks and then months and then years went by, I realized that I had found a home in the legal field. And I know that would not have happened were it not for Sally and the way that she approaches her practice. When I was young, I was drawn to the world of theater because I saw it as a means of amplifying stories, of giving a voice to people and characters that otherwise would have gone unnoticed and lost. And working for Sally, I saw that attorneys had that same opportunity, but in a much more meaningful way. Most people, being in a courtroom is a scary experience. Being involved in a legal matter is stressful and confusing, and Sally keenly understands that vulnerability and responds with kindness and tenacious advocacy. Time after time, I have witnessed new clients walk into Sally's office. They're nervous, they're out of their element, and they need help. Inevitably, I watch those same people walk out of Sally's office after sitting down with her and discussing their case, visibly relieved. They've had the good fortune to meet someone who listens with compassion, gives them a straightforward assessment of the road ahead, and vows to amplify their stories so that they can be heard. And over the years, Sally has been incredibly supportive of me and my story. She fostered in me a deep respect for the role an attorney can play in a person's life. She has taught me to trust my abilities and always work harder. 2013, after many years of prodding by Sally, I enrolled in law school. And I would not have gotten through that grueling experience without Sally's support and advice. And I now have my own thriving law practice, and I can fully appreciate how Sally has guided me to where I am today. Sally is a terrific attorney and a better person. She is kind, she is professional, she is extremely capable and hardworking, but most of all, she treats everyone in the room like a human being. She understands that everyone's story is different and deserves to be heard and considered. And confirmed, I have no doubt she will continue to exercise that same humanity and integrity, both on and off the bench.
Thank you. Do any of the council have any questions? Councilor Devaney?
Oh, thank you for coming. Your testimony means a lot to me because you have seen her day to day. Probably seen her in more hours than her husband has in 21 years. And it says a lot for you to come. And I'm sure she must have inspired you to be a lawyer, did she?
Yes, yes. I had my own self-doubts over the years, because it's,
But you could have been an actress.
call me a lone baby, but yes, she did, and I don't think that any other attorney's office would have had that same inspirational aspect to it, where I could marry, my interest in amplifying people's stories the way that theater does, but, in a way that you're actually involved in assisting people.
And did you find her being helpful while you were going to law school?
Oh, yes, yeah, because I continued to work during the day and I went to school at night. So you can imagine that imposes a little bit on an employer. I come in tired, catching me working on, papers and things like that. And then just giving input on how you get through that process and how you
That's
get
right.
through.
Well, that's caring. That's caring.
Yes.
Right.
Yes.
Well, thank you. Your testimony means an awful lot, really. Thank you for coming.
Thank you very much. We appreciate your testimony. And our third witness just arrived. I saw her going the wrong way. We usually have a different role together, but Assistant District Attorney Lindsay Leger.
And my apologies for being late. I'm not used to coming into the city, and the parking was shut down every place that I thought I was going to park. So my apologies. Not a very good impression to make on the council this morning.
You've already made a good impression on me over the years, so you don't do it.
Thank you. And if it makes you feel any better, I lost a shoe.
Oh.
So it was in my bag.
You're up.
Thank you. Good morning, councilors. My name is Lindsay Leger. I'm an assistant district attorney with the Essex County District Attorney's Office, and I have been for almost 11 years now. Actually, next month, I begin a new chapter in my legal career because I accepted a position with a nonprofit animal welfare organization, the MSPCA, as a staff attorney.
I don't think I gave you permission to leave. You do that.
You did it, and I haven't talked to you yet, so.
Go ahead.
It's a privilege and an honor to be here today testifying on behalf of SallyAnn Janulevicus in support of her nomination for Associate Justice for the District Court. I am grateful to have the opportunity to be a part of this process and very thankful to SallyAnn for having me here to support her on a very important day in her legal career. I have deeply reflected upon my career as an ADA over the last several months, and I can tell you that working with and building both personal and professional relationships with lawyers like SallyAnn is one of the things I am most grateful for and that I will miss the most. I urge you all to vote in favor of her nomination because she is one of the kindest, most compassionate, hardworking, and dedicated women and lawyers whom I've had the opportunity to get to know. I've known Sally for approximately 7 years. And although the assumption would be that I met her in the courtroom, our professional relationship did not begin until several years later when we met in the Lynn District Court. I was pleasantly surprised when I learned that she had begun taking cases as a bar advocate there in Lynn, and we were able to reconnect after not having seen each other for several years. And just like a great friend, it was like no time had passed. We first met back in 2014 at the Boston Sports Club. Both of us worked out early in the mornings before heading to work for the day. Although I definitely do not consider myself to be a morning person, and my dedication to an early morning fitness routine has certainly had its ebbs and flows over the years. I know that is not the same. That is not true for Sally, and I know that she continues to be at the gym bright and early every single day, even today. And even though she didn't know it, SallyAnn's dedication to her health and fitness helped to keep me accountable to mine without, for lack of a better term, judging me negatively when I missed more than a few days, probably more than not. SallyAnn and I bonded over our love for the law and possibly to be expected by some, our compassion for animals. And having spent a significant portion of my career prosecuting animal cruelty cases, a niche that I have found over the years in my career, we spoke a lot about dogs and the love of animals and the link between human violence and animal cruelty. Although I did not have many cases of my own with SallyAnn in the almost 5 years that I worked in the Lynn District Court, I can tell you that she was always extremely prepared, hardworking, courteous, polite, and even-tempered as an adversary. And working with her was always a pleasure because she just got it. And as a defense attorney, although her priority was to her clients, her compassion extended not only to those that she represented, but to victims and everyone else that was involved in a process that is not always easy to navigate. It did not go unnoticed by myself and my colleagues that she tried not to re-victimize a victim if at all possible, which is not always the case with some attorneys. I never knew her to file any frivolous motions on cases, as other lawyers do from time to time, and she would come to court prepared, file written motions, written memorandums when required, and sometimes she would do it just to protect the record even when others would not. And negotiating with her was always a breath of fresh air. Working in the district courts can be grueling at times for everyone in the courthouse, and SallyAnn always made sure to ask how everyone was doing and took interest in those around her, including those in my office. She knows the law, she fights for compliance, conviction, but she knows when to back down, when arguing further would have negative consequences for her client. And she was always respectful to her colleagues, her adversaries, and to the bench, and appreciated and respected the ADA's time in the busy court like Lynn. And as a supervising ADA in Lynn for many years, I had the opportunity to observe her to have a great working relationship with everyone in the courthouse, including my staff. And although I sadly won't have the opportunity to argue before her as a sitting district court judge on behalf of the Commonwealth, if confirmed, I am confident that if you vote favorably in support of SallyAnn and her nomination, that she will administer justice fairly and impartially, and that she is worthy of this nomination. And I thank you very much for your time.
Councilor Devaney?
Thank you for coming.
Thank you.
So, how many years have you known the nominee?
So about 7, and like I,
You said there wasn't a lot of cases in those 5 years that you knew of. Is there one that comes to mind that impressed you?
I would say probably one of the last case that I handled with her. And unfortunately, I didn't get to see it through because I was promoted up to Superior Court, so I had to give it to somebody else. But it was an extremely complicated child abuse case with like a neighbor dispute that was kind of intermingled with it. And there was a what we call an adjutant issue, where there was a claim that not our child abuse victim, but her who were involved and observed the alleged incident had quite a history with the police department, and it caused some issues with of their own with other individuals. And she went through the process, filing the motions appropriately, and we litigated them as best we could until I could keep the case. But it was an extremely difficult issue, I think, that we don't see very often, especially in the district courts. And she was able to navigate through the issues, and we worked very well together, I thought. I think we both kind of learned a lot in the process, and every day you kind of learn something new, and that's an issue you don't see very often. Even in my, almost 11 years, I only probably litigated a motion like that a handful of times, so I was very impressed with that.
The child abuse cases, I can't even imagine being in court representing those cases. And what's very disturbing to me, it's increasing every day. There isn't a sentence that is appropriate for these people. But anyway, you use the word that I look for in a nominee, compassion.
Certainly.
I don't vote for anyone if they don't have compassion, and you said that. And that, and not only that, but, you said that you have been an assistant district attorney. I'm sure that you've seen many nominees that have come before us. This is the first time that you've come.
It is.
How long have you been there in the Essex?
So almost 11 years.
Yes. Well, thank you for your service, and I appreciate it. It was hard though. Thank you.
Thank you.
I'm gonna miss you.
I'm gonna miss you too.
Mr. Chair,
Yes, Councilor Hurley.
good morning.
Good morning.
I just have one question of the witness. Why are you leaving the district attorney's office to go to the MSPCA, to which I am a contributor, by the way?
That's amazing, thank you. I will tell you that it was quite a struggle of a decision. As I indicated in, my introduction, and, in my testimony, a majority of my career, I've done vertical prosecution of animal cruelty in the Essex DA's office. We had a grant for some time from a foundation to do that. And I kind of supervised, and I was the single ADA that handled the majority of the cases in the office. In doing that, was able to network, and I've interned at MSPCA during law school. And it actually was an opportunity that just kind of fell in my lap. I wasn't out looking for it. It was a hard decision to make. It's the best job I will ever have, and I likely will always consider myself to be a prosecutor, and you never know, I may end up back there. But it's an opportunity that I'm really excited for. It's something that I think I can do a lot of good for animals, and really advocate on behalf of, as I indicated, the link between human violence and animal cruelty. And I want to be able to have the opportunity to educate the bench, to educate the bar advocates, the prosecutors, law enforcement, and help train them in hopes that I can do a little bit more good for everybody and have public service be in that fashion for at least the time being.
Now might be a good time to show her your dog, if you have your dog.
Well, Maggie, come here. Come here. Come here, sweetie. Come on.
She has a dog, okay, we've all seen it. Oh, there you go.
This is Maggie. This is my second one. My first one was Molly. And before that, I had a rescue dog, which was a lab chef combination, whose name was Mulligan, because we gave her a second chance and we were golfers, so we figured it was appropriate. Can't tell you how great it is to have a dog. They never complain about your cooking. They're always happy to see you, and you don't have to pay for a college education.
It is so true, so true.
So I wish you good luck.
Thank you.
And just before I go silent again, a big hello to Peter Agnes. I didn't get to say hello. It's great to see you again, Peter, and the aging process has done you well. So nice to see an older, as in former colleague, not old as in person. So thank you very much, and I think that you did a great job testifying.
Thank you.
For you, Counsel, I'd like to ask Mary a question. Mary, did you bring your dog to be blessed Sunday?
Of course.
Well,
We brought a brother here to, just in case, where you go, man?
I brought my cat to be blessed. I thought she was gonna have a heart attack.
I think, Lindsay, I think you won over more votes than the nominee did. Maybe you should switch seats.
An error.
It might be the time to switch seats.
Mary, she was
Seriously.
peoples before, so something.
Seriously,
Blessing.
I've had an incredible amount of interaction with Lindsay over the years, and we've had a very, very cordial and warm relationship, and I really am gonna miss you. You were a great prosecutor, and go there for a couple of years and circle back, because you belong in that seat.
That is the highest compliment I could get from you, and I
I am gonna miss you.
that
No.
this opportunity has been a wonderful experience, especially to end, my career and having the opportunity to do this. So being across from you and, in this forum instead of in a courtroom and bickering back and forth here and there, it's a great experience. So I appreciate it.
Thank you, Lindsay. Now, we're going to close the part of the hearing for witnesses in favor of the nominee. Are there any witnesses here to testify in opposition to the nominee? It's a good thing the Statehouse is closed, huh? We did receive a letter in opposition. I'm not going to read the whole letter, but I do have to put it into the record. It's from a gentleman by the name of Michael Yang. I spoke with Mr. Yang at length yesterday. He called me. He had some concerns about you in a courtroom. He is a litigant on the other side of a divorce. I'm going to put his letter into the record. All the counselors will receive a copy of that, and they can certainly take it into consideration. In my conversation with him, I don't believe that he had a full understanding of what a lawyer's obligation is in terms of representing the client, and at what stage of the proceedings he was at. It's my understanding that there was only one hearing for temporary orders in that case since it started. And he makes some accusations in a letter that you made some misrepresentations. And without getting into any attorney-client privilege with respect to that, which obviously we can't do, it was clear to me that whatever representations you made during that hearing was information provided to you by your client. And it's not information at that stage that is challenged by way of cross-examination in a trial setting. So I don't think he fully appreciated that the way you challenge statements that are made that come from another party in a lawsuit is through cross-examination in a trial or an evidentiary hearing. It's my understanding also from talking to him that he did sign a stipulation and agreement with respect to seeing his child and support and everything else that went with that. So this is part of the record, and I'm putting it into the record. It's something that people can consider. I was on the phone with them for a good hour yesterday. I also reached out to a number of probate court judges yesterday to talk to them about this, and every single one that I spoke with, absolutely 100% had high praise and no concerns about you at all. So just so the record's clear, that's part of the record. His name's Michael Yang. He wrote a 2-page plus letter that all the councilors have and can have an opportunity to review and question on if they like. So we'll leave that there. So that would close the period of time that we have for witnesses in opposition, and the floor is yours.
Thank you, Councilor Kennedy. May I stand?
You may stand, you may sit, you can leave if you want.
Run out the door. My name is SallyAnn Janulevicus, and I'm so honored by the opportunity to be here before you, and I'm so grateful to both the governor and the lieutenant governor for this nomination. And I would like to thank Chairman Dossier and the entire JNC for having the faith in me to promote my nomination and to have gotten this far. I'm also very thankful to the executive director, Lauren Green, Chief Legal Counsel Bob Ross, and to all of you, those who are joining us by Zoom and those who are here. I really appreciate your thoughtful consideration and the amount of time that you've spent with me. It's really been very touching. Thank you. I was born and raised in Barre, Massachusetts, and when I got to BC, there were more people in my graduating class than in my hometown. My father was a union laborer for almost 40 years. He's actually been a member of the union for more than 50. My mother was a hairdresser when I was a child, and she became a real estate broker, Counselor Duff, while I was in college. And it was not easy for them to send their only child to Boston financially or emotionally. And every day during my first semester at BC, my mom would call me crying and say, come home and go to Holy Cross, I miss you. I was actually the first person in my immediate family to go to college, let alone law school. And my maternal grandfather came to this country at 16 from Italy, speaking virtually no English, and got off a boat and began a life in a country where he had nothing and no one. He was a mold maker at Allen's Foundry, where they actually make Allen wrenches. And my father's grandparents came to America from Lithuania. They were fleeing the tyranny of the Bolsheviks with small children, and they came here and they worked a family farm in Barre. And 3 of their 6 children served in World War II or Korea, all of them coming home either very badly physically harmed or emotionally harmed. And so it's easy to see that the college experience was very far from my family's experience. This was something that they didn't know or understand, but my wonderful and supportive family and parents, I couldn't have picked, if I had to pick parents, I couldn't have picked better people. And they've supported me throughout my 58 years journey to this moment. While I was at BC, I worked a work-study job at BAPS Library, and I waitressed at night and during the weekends. And I missed a lot of football games and many parties because my college experience was not about partying. It was about becoming a professional and in particular, becoming a lawyer. Worked my way through New England School of Law, as well. And shortly after I had passed the bar, I opened a sole practice where I shared an office, I shared a desk, a printer, and a computer. I didn't have my own computer at the time. I traded work for space in those early years, and I went to district court literally every day of my career for the first 10 years of my practice. And for the last 20 years, I've probably been in district court 2 or 3 times a week on various motions. I started in the BMC where I met Counselor Kennedy and knew him from our trial work at the BMC. Seems like another world.
A long time ago.
Counselor Jubinville as well from the BMC. And I like to tell people that I actually grew up in the BMC because it was there that we saw so many things that were beyond my personal experience until that point. My career has been dedicated to protecting the constitutional rights of the accused and often forgotten populations of our communities, meaning the homeless, the drug and alcohol addicted, the mentally ill. And all of those things, of course, are very prevalent in indigent defense work in the district court. My pro bono time has been devoted to HAWK, which is a violence prevention program on the North Shore in Essex County. STEP, which is a sobriety treatment and education program that was formerly in the North End. But I've recognized throughout my practice that these are the issues that we need to address and we need to be concerned about in the district court. And so I've focused my free time on the things I thought were helpful in my community. I think that I brought my mother's philosophy to each of these groups and to my work as a sole practitioner. And she would send me off every day with these words, which, you know, we laugh about now, but I think that they're the reason I am who I am. She'd say, have a good day, mommy loves you, and don't let anybody push you around. And she said that to me every day for 12 years of my life. And I think that's why I've always believed in standing up for the powerless and the voiceless, because of my mother's words. It was about not letting people trample over your rights and what you knew to be the right thing. I recognize after 30 years of practice that there are sometimes where good people do bad things because they have bad circumstances and no opportunities. There are also times where bad people do really bad things, and we have to recognize and protect the victimized from those people. But I think it's part of our responsibility in the district court to provide opportunities for people to be a productive member of our society, and if we can help them to do so, to help them either with the community court programs, drug court, gun court, homeless court, veterans court. Those are the important neighborhood-focused responsibilities of the district court. And so I hope that you will all vote to confirm me, and I promise that I will not embarrass any of you during my time as a district court judge if in fact you do vote for me.
Councilor Ferreira.
Thank you, sir. I want to thank the nominee for speaking with me at length the other day. I can say my observation of you standing up today is the first time I saw a nominee stand up. So I think the way you took control of the room just now is probably equal to the way you stood up for your defense, your criminal defense clients throughout your career. I admire the path that you took. I like your philosophy about recognizing the difference between good people having a bad day and bad people needed to be put away. So you definitely have my support for next week. Counselor Kennedy twisted my arm when you first got nominated, said how great you were in the district court and the vast experience you've had. It's very admirable that you've had your own practice for so many years and made it all on your own. So congratulations for a great career. And I think you're going to be great on the bench. And thank you for your public service, helping those in need as well.
Thank you, Councilor Ferreira. Councilor Hurley.
Yes, thank you. I would indicate that as it relates to your experiences, you've done a number of divorce cases over your career. When I was a lot younger and I was in practice, I had both criminal practice, civil practice, and a divorce practice. And by way of observation, I would indicate that without getting into anything covered by lawyer-client privilege, people in a divorce situation can sometimes be good people who you see at their worst. And sometimes, we used to say in district court, the people that you see are bad people trying to look their very best. So the letter from Mr. Yang is something that has, I believe, an emotional basis to it rather than a factual basis. And your obligation to make representations as made to you by your client is part of being a good lawyer. So they used to say, hell hath no fury like a woman scorned. Not the case. Hell hath no fury like any divorce participant who feels they've been scorned, whether it's true or not. So I would tell you, I'm not going to give that letter any weight in terms of my consideration of your nomination. I do have a couple of questions. When you are faced with someone who has done something that is, well, let's do this. Let's say someone has broken into my car, so I am the victim, and stole the $100 that I had in the car, broke all the windows in my car, flattened all my tires with a knife, and proceeded to scrape with their crowbar that they broke in with every side of my car and its paint job. And that person comes before you and got caught. Because right after he finished scraping the side of my car, the police were called and caught him with a crowbar in hand. So you look at his record, and his record indicates that he's got a 3-page record that involves drugs, other types of violence, assault and battery with a dangerous weapon, etc. The district attorney's office requests a year in the House of Correction, and the defense counsel says that it's not his fault because he's a drug addict and he should be sentenced to some kind of a program. Now, don't forget, I'm sitting in the audience. What would you do?
So thank you for that question. I believe that that's a particularly vicious crime, that is motivated by a certain level of maliciousness that can't be tolerated. And you have to consider the victim, the fact that they're entitled to protection under the law. And I think that that is perhaps a person who should spend some time incarcerated. And certainly they can get resources for drug and alcohol addiction in a confinement setting.
All right, thank you. Yesterday, someone filed a bill so that every first-degree murder case would be reviewed after 25 years. So that means that every defendant who was found guilty or pled guilty to first-degree murder would be eligible for parole after 25 years. I am the relative of a victim, an 80-year-old woman living in an elderly complex whose apartment was broken into. She was beaten, she was raped, and then dumped in the bathtub, and some type of strong cleaning agent was then dumped all over her body so that there wouldn't be any forensic evidence. He then stole the little jewelry that she had that was more of sentimental value than of value and gave it to his girlfriend. And he was caught. And he was also suspected of doing other break-ins where no one was injured. He is serving a first-degree murder sentence. As a relative of that poor woman, who saw her immediate family go through such pain and suffering themselves for the loss of their mother in such a violent way, do you think that it would be appropriate for the legislature at this point in time, which could affect the sentences that have been imposed over the last 30 years or more, to be able to change by law the sentence that was imposed on these people?
No.
The district court is also a court of second chances. Someone comes before you and they have no prior record, but they are charged with possession of cocaine, possession of marijuana, and it's at this point with intent to distribute. The district attorney asks that you sentence him to jail after having been found guilty by a jury. The defense says that he doesn't deserve jail because of the fact that he's got no prior record, that he is in fact himself a drug addict and doesn't need jail. He needs sentencing to some type of rehabilitation program. What would you do in those circumstances?
I believe that that is the perfect situation for some kind of restrictive probation where we keep tabs on him and we understand that he has the obligation to enroll, if you will, in a rehabilitation program. But I do not think that that particular case warrants incarceration.
Okay, thank you. I appreciate the number of years that you've served this Commonwealth as a defense counsel and been involved in a lot of good curricular activity or extracurricular activities. And you're the kind of person who has the education and the experience to make a good judge. So I thank you, and I'll be voting yes for you next week. Oh, and by the way, Counselor Kennedy is guilty of twisting my arm. So that would be an assault and battery. What sentence would you give to him?
Okay with wrestling for a fat old guy. Counselor Devaney.
Nice to see you again. Thank you for all the time you afforded me. It was my pleasure. I want you to know, well, people should know that the Governor's Council questionnaire that we require you to fill out, it asks you to return it completed within 8 days before your hearing. 8 days before your hearing, the governor hadn't even appointed you. So I'm sorry for that, because you only had 3 business days, and I want to thank your witnesses to come in that short time. And I think, the public needs notice. They need notice, and that really wasn't enough. But anyway, you're here, and it's fine. The other thing I want to make notice is that the council had a special meeting about the use of Zoom. And collectively, the council agreed that only Mary would be the only one to use it because she had a doctor's note that said that she couldn't drive from the western part of the state because she had a back problem. So I'm just putting that on the record that if you can't make it, you don't make it. And that happens all the time. You can be in court, whatever. But I think when we have a meeting and we all agree on that I have to speak out and say, this is not what we agreed on. And I think, we all respected Mary to have her do it, and Mary's the only one. People could have, a funeral, whatever, it's understandable. but you don't use it to resume. You just don't come if you can't come. So I just want to say that out in the public. Okay, so I want to, I always ask the nominees, your attorney here. And I just want to know, just this time, on the JNC, the Judicial Nominating Committee. Now, for people out there, I like to tell them how the process is. And every governor appoints 21 lawyers, and they have an amazing responsibility and authority that we don't have. The council only has one person to vote on. They don't know how many applied, nothing, okay? Now, these 21 lawyers have the awesome responsibility to decide who's going to get an interview, who's going to be rejected, and who's going to be presented to the governor as their choice to be a judge or a clerk magistrate. So, having said that, I have a big concern about this particular JNC. Because in this Baker administration, there has never once been 21 lawyers at the hearing. That to me is egregious, because they vote on someone they didn't see, they didn't hear, they didn't talk to. So I'm just saying that just to educate, not to educate you, you know, but I just want that out there, that people do know, and it's wrong. And in the Salucci administration, there was a JNC, director who, those 21 lawyers at that time, and said, if you don't come to the hearing, you don't vote on the nominee. God bless him. Wonderful serving with him. He was, I don't want to cry, he was a good person, and I know what you thought of him too. So, having said that, you had an interview with the JNC. How many of those 21 lawyers were there?
Recollection is that there were 6 on Zoom and
So. 8. So the majority don't know you, don't see you. But see, that's what's wrong. I can vent. I can say this. I have no authority, no one's listening, no one cares. So it's going to continue, but it's wrong. If you have that responsibility to give someone a lifetime position, that chair should demand that you be at the hearing. So thank you for letting me vent. I appreciate that. Okay, so now let's go back. You've had a history with the JNC that you have applied before. First of all, no apology is necessary, because I'll tell you, I've been here 21 years, and political nominees jump the line. And I want to thank you. I want to thank you for reapplying, because we've had good people that have reapplied that have been rejected. And what a loss it would be to the court, really. And so now, having said all that, tell me what your experience was in the past. Generally applying.
I have interviewed several times with the GNC, and on 2 occasions I got to the chief legal counsel, but not past that.
And did you get to the governor?
No, not previously.
Okay, I just wanted to clear that up so people know. And I mean that. We've had such good people that reapplied. But on the other hand, I know people who applied and have been rejected. And when they see the person, 13 years as a lawyer, whatever, and no criminal experience, whatever, and they see that person getting appointed, they never will apply again. And that breaks my heart, because I want this to be open government to everyone, okay? So I'll get off that. Now, first of all, as I say, I do not have a poker face, and I should reveal it now because I'm voting next week, but I am so pleased. I can't tell you how pleased I am. And the one thing that I look for, and one of your witnesses said it, was compassion. And you have it. You have compassion, you have empathy. That's what I look for. And it's funny because I always say it, and I say it so much that it's ridiculous, that when Mr. Dacier is present at a hearing, when I meet with the nominee, they tell me, he always asks, what's your definition of empathy? So that was from me, I guess. So anyway, but now, first of all, I'd like to talk about your restraining orders. We don't hear a lot about that with the nominee. And tell me what your experience has been. You know, for me, I'm concerned that how do you determine as a judge that that person is reliable, is being truthful about that? And so how do you?
That's the difficult part of a restraining order, because you're first seeing a affidavit that's signed that hasn't been challenged, that oftentimes our day order has issued. So in my mind, that defendant should be afforded the ability to be in court as soon as possible. I don't like to see anybody deprived of their home or their children and their family without having an opportunity to appear before the court as soon as possible.
Now, with this pandemic, you know, as an outsider, what bothers me, it seems to me, I want to see that person. I want to see their body language. I want to see their expression. How do you do that during the pandemic?
It was very difficult. Most of those hearings were by Zoom for a significant period of time, and they mostly all entered.
Yeah. Well, you know, in my 21 years here, it's been my experience that men really get the worst end of this when it's a restraining order. And I just want to tell you, I didn't know the time that we spent, I didn't tell you, that's the reason I ran for this position, because of restraining order. I had a friend who was in a very dangerous situation with a boyfriend. And it became so serious, he was physically abusive. She had gone 7 times to court, hoping that the judge would help her, give her some help. So the 8th time that she was going, my late husband was a firefighter, he had a good friend that was a police officer, he had him go. This police officer went with my friend and told the judge, he's in fear for life. Give him a $200,000 bail. $200 bail. He turned to her in fear, she paid it. The judge said to my friend, you have been wasting my time and the court's time coming here 8 times. Now, our police officer friend said that he was out the door before the boyfriend. 2 weeks later, my friend was dead. He killed her. He killed her. So I didn't know governor's counsel. I never knew what it was. On the ballot, it says counsel. So I didn't know how judges got there. I'll admit my stupidity. I didn't know how judges got their jobs. I thought that maybe were appointed. So I found out, and I found out it was the governor's council that gave that approval. I looked at all of the duties, and I looked into all of the commissions and everything. I said, I can do that. And that's why I ran, because of restraining orders. So that's very important to me, and I've been especially concerned, as I said, during this pandemic. And I say, how do they see it? Can't even see it, can't hear them. And how do you make that determination? Even in person, I don't know how you do. So that's a big concern of mine. So, okay, so how do you determine?
I think it's important to know what the history between the couple is, that you give some consideration to the allegations.
Yeah.
I think it's important to hear from both sides as to what the situation was. If there are witnesses, I think you need to have those witnesses there and available as well. And really knowing the history of the couple and knowing what the background is should give you, if nothing else, a gut feeling as to, is this a reliable piece of information? And that's really what you're looking for, is reliability of the information. You very rarely have an evidentiary hearing unless you're really lucky to have a district court that gives you that kind of airtime. So I think you have to make the gut decision, but it has to be based on the reliability of the information in front of you and the history of the folks that are there.
No, and I agree, it's a difficult thing. The other thing is, we don't talk about, and you've been 30 years, and I want to go back to that, because.
Started when she was 10, by the way, Marilyn. Started when she was 10.
I know. Jokes great. But you know, when I think of your 30 years, and I think you are a solo practitioner, you know what that means to me right now? That tells me you were responsible for the casework, for the compliance, and the management issues from start to finish. And then to shovel the walk and pay for the rent and all of that. That means a lot to me, because I think that gives you, this is my own opinion, that it gives you more, when you're a judge, that you have more feeling for that person coming in who's paying big bucks to the lawyer. And I don't know, I know everybody comes at 9, but maybe you can arrange it so, yeah, I'm gonna take that one and do that first or whatever, I don't know. But that's one of the things that concerns me. In your 30 years, you've seen all kinds of cases. And what is most important to me is your service, public service pro bono, okay? When we're getting 4-year-olds. I don't want 4-year-olds, I want someone with your age, with your experience, life experience to bring to the court. That's what you need, besides and all of that. So, with that, I want you to talk about some of those. It's very impressive, and you're still doing it now, which is wonderful. We had a nominee recently, and he was in your age bracket, and I was so happy to vote for him. And he said in his JNC that before you're a judge, you should have public service and volunteer. And you know what? We don't see that in 40-year-olds. We don't have time for that, But you have right up till now. So I'm not going to do any more talking on that. I want you to tell me all about that, each of those things, because it is very impressive. The healing abuse, full purpose, all of that. So I'm going to let you go through each of them.
So with HAWK, I have been a pro bono attorney, which means that I have met with victims, both men and women, who have been victims of domestic violence and crime in the home. I've given them counsel with the different courts, how to get through the restraining order process. I've helped them write their affidavits for the restraining order. I've also given them counsel with regard to filing divorce, making permanent the restraining order, or trying to get the children squared away so that the children perhaps can still have a relationship with one of the parents that would otherwise be cut off at the restraining order level. And I've done that at least monthly for a very long time. I have worked with STEP, which was in the North End for many years and unfortunately no longer exists, but it was a 24-hour, 7-day-a-week drop-in drug and alcohol treatment program. And our goal at STEP was to have violence prevention programs, preventative activities. We had a youth organization for young kids from the neighborhood who were starting to get into drugs. And actually our model was studied by Boston University and became a model for drug treatment across the country.
It's wonderful.
Very proud of that.
And ARC?
And ARC is a group which appoints attorneys for children in a divorce case, separate from the parents and separate from the parental representation. I'm appointed to specifically talk to the child, ascertain that child's wishes, and with regard to parenting, custody, what might be going on in the home that they want to present to the court, not in a GAL capacity, but in the capacity as that child was also a parent.
That's so important, but some children, I have 4 children, some children don't come forward to to tell you those things. How do you approach that?
Well, I approached it by actually spending time with the children. I would meet with them alone. I would try to meet them in a coffee shop or at a playground so that we could have private fun together. And I found that most of the children were very open to discussing with me what they
Now,
wanted.
how young a child would be involved in that?
The youngest child that I was appointed to was 10, but I have also represented children of 13 or 14 years old. And I had not represented anybody that was younger than 10. And they're very articulate children.
Yeah, you were involved in other things too. The bar conciliation
Yeah.
program?
I did at least one a week during the pandemic. I would meet with people, try to settle cases that were not getting before the court because of the pandemic and because of the closures of the court.
Tell me, you were on the Board of Bar Overseers. What did you get from that? What did you learn from that could be applicable to being a judge?
Well, as a hearing committee officer, I spent time receiving evidence, making rulings on evidence, and actually the last two that I have been the chairman of, they've reached a deal either before the case started or after we've had several status conferences and pre-trials. So it really was an evidentiary, and as a hearings officer, you're basically in a judicial capacity.
30 years and how many cases? Hundreds.
Thousands.
Well, I want you to know, this council approved someone to go to the Superior Court with 6 cases in 21 years in the Superior Court. So you can see how pleased I am to see you today, because you could go to Superior. But anyway, I don't have that level of appointment. So, okay, so going back to some of your cases, you know what always amazed me, and we don't often talk about it, and in 30 years, you've had mistrials. Now tell me, what is the criteria to have a mistrial, and you, being a lawyer, what alternative did you have? What appeal is it? What happens? Tell me about one of your cases.
Well, the last mistrial I had was an issue, actually, it inured to my benefit. I had an OUI second where the police officer was specifically instructed not to testify about certain elements of the case after a motion to suppress. And in the middle of his testimony, he did it anyway. The first time he did it was a sustained objection, and the second time he did it, I moved for mistrial. So and ultimately, my client was able to work out a broken down charge, so it was reduced from a second offense to a first offense, and it ended up being much better for her.
And then there was a 58A case, Ellen Flatley, did I get the name right? Ellen, it was strangulation and domestic assault and the whole 9 yards. Right.
We had a significant, long evidentiary hearing on that case, yes. And ultimately, I tried that case, and the defendant was found not guilty after trial. Of course, he already spent about a year in jail, so.
Right. So, in your 30 years, is there one case that comes to you that was so meaningful and so rewarding that you will never forget it?
May I tell you this story?
Yes, tell me about it. Tell us about it.
So, Lynn District Court on a Monday morning, being assigned to represent some folks in lockup, and the first woman I interviewed in lockup, and I'm sure Councilor Kennedy and Councilor Jubinville know the jail breath, the smell of vomit, Monday morning.
It goes away when we leave.
My client had a very badly scabbed face, her hair was scraggly, and during the course of my interview, I always asked about her family. And when I asked her about her family, she began to sob, weep inconsolably. She had just lost her 5-year-old son to DCF because she had such a significant drug problem, she was unable to care for him. So I worked to get her into the Essex County Sheriff's Department detoxification program. While she was being held and before her next court appearance, I found a placement for her in a residential treatment program called Edwina Martin in Brockton. Then I would say about 8 or 10 months later, after she had pled to a probationary period that included a requirement that she go to the Edwina Martin house, I was in Brockton District Court for a hearing, which I never do. I'm never in Brockton for court, but I was pulling through the Dunkin' Donuts, and as I pulled up to the window, the drive-through window, there she was. She was working at Dunkin' Donuts, and her face was clear, her eyes were bright, her hair was clean, she looked amazing. And she saw me, and she called everyone in the store over to the window to say hi to her lawyer, and she started to weep, and she said, I saw my son after it's been over a year, and I saw him last week, and she said, I wanted to call you and tell you, thank you for saving my life and getting me.
Wow, what are the chances in the world that you'd ever meet her like
It
that?
was crazy.
Isn't that wonderful?
And we were also welled up that it was amazing, but.
Yeah. So the most disappointing outcome was, in the cases that you can think back, what would it be?
And each and every guilty after a jury trial, but I recall the first federal case I tried. We started with 8 defendants, and on the first day of trial, after opening statements, we had only 5 because 3 had turned state evidence. And it was very disheartening, mostly because my client was about 21 years old, had been accused of trafficking cocaine. His girlfriend, about 18 years old, 7 months, 8 months pregnant. And it was just disappointing to him. He was just so devastated that his friends would turn on him like that. And actually, the girlfriend had asked me to get permission, and I did, from Judge Lavelle, to have them married in the courtroom before he went for his period of incarceration. And for years, I got pictures of the child, and I don't know how they are now, but it was certainly a very disappointing moment to see so many people turn on their comrade.
All justice isn't equal, is it, huh? No, just a year or 2 ago, there was a judge in Massachusetts that had an illegal immigrant in front of him, and he was a big drug trafficking guy, and the police were trying to get him for years. He even had compartments in his car that, you wouldn't see it. They were, you wouldn't see the drugs. And he gave him 2 years probation. And I heard the tape, and he said to that illegal, if you were a citizen, I'd put you in jail. But you're providing for your family. I've had 2 friends the past few years who lost their son's overdose of heroin. I wonder if they would agree he's providing for his children. And it is really upsetting. And there were letters here, about 60 legislators signed a letter. They wanted a hearing for this judge. Nice guy, I call him myself. He's a nice man. So he continues. So that really bothers me because, to think they were still together, that couple, and she was sending you the pictures, that's sad, But the other thing is that I want to thank you for being involved with women detox centers and everything. We talked about it, and it goes nowhere. I keep saying that we need more drug treatment centers. And I don't care what legislation that they put out there. You don't have long-term. That's why my friend's 2 sons died. You can't just have them go away in a weekend or whatever, and they really tried. So I thank you for that. But, you have taken the time, even up till now, to volunteer and give all the service. I won't go into all the cases, but you've had, and I like the idea that you have a lot of criminal cases. I think what we're seeing out of society every day in the Boston streets and everywhere, we need someone that has criminal experience. And I just have my own little theory that if you're an attorney and you've never done criminal work, that you'll be reluctant, you'll be timid to give the right sentence for people. That's my own opinion. But, you know, I'm not going to go into all of them. We spent, oh, I don't know, 4 hours, I think, but you have everything. I mean, you've been in every court, probate, all of it. So you bring all that to the court. But most of all, you bring your empathy in, you know, I don't want someone learning on the bench. And we're voting, I mean, they're voting for people learning on the bench. That's not what I'm here for. And I hear from lawyers out there who have, you know, 25, 30 years experience, and they're being rejected by someone 12, 13, 14 years. And we had someone that worked in a city hall. He was one of 13 assistant solicitors, and worked for the sheriff. And he went to the district court. And I know people out there that can't get an interview or they get rejected. So I am so glad you did it. You made it, you got through, and after all of this, I'm glad that you didn't give up, because we need you. We need your experience. We need your kindness. And obviously, you witnesses, you know, and to have these wonderful people to be here for you. And I want to congratulate you on being Italian Woman of the Year. You know, not for anything, I'm not getting any award, but I'm the first Italian American woman since 1780 on the Governor's Council. But I said, oh, that's great, you know. But anyway, it took me a little longer. But anyway, I am just so delighted, and it was such, it's such an opportunity for us to talk with Belgian waffle. So, but I can't have room on the diner because there's not enough room for Justice Island and for all of them to be put up there. But we have an imaginary one anyway. But thank you so much. The other thing I do want to mention is, I just got that letter of someone, you know, that is opposing you. I just want you to know, we're a public forum, and we have people that come for and against. We had 7 people in opposition to a housing court, even the former fraud prosecutor, Interpol, came and said that this person lied in Superior Court. So it's done all the time, okay? But that's different. That was documented. Yes, wasn't. But all I'm saying is, everyone has the right. They don't need a tribunal, that he was told. But the thing is, you know, we had 7 people that went into details about this housing court nominee of what happened to him. And he's in the housing court. Not Michael. But anyway, so I'm saying that I want people to know, because we had an industrial accident board member, and we had 2 attorneys came in and detailed the egregious things that she would say to the nominee. And I'm allowed to tell you, and it's embarrassing to even tell you, one of the things she said, and they said it when they came and were witness. This very disabled worker came before her, and he came in with his pregnant wife. This is so egregious, there's no words to even describe. This judge said to the disabled worker, "Is that your wife?" He said, "Yes." If you can do that, you can work. We don't want judges like that. No layperson would ever say anything so disgusting. So I'm just saying that people do come and oppose. And I welcome both opposition, because that's where it is, on the planning board, the zoning board, the legislative committee, and that's what we're about. And I'm very pleased. I mean, you have, a superior record of, my God. So I'm going to stop now because I've said enough. But thank you for reapplying. That's my biggest thank you. Okay.
Councilor Depalo.
Thank you, Councilor Kennedy. Good afternoon. So you're an Italian with Central Mass roots, but I am going to ask some questions nonetheless. So you have a lot of experience around mental health, And I just wanted to ask something that I think I know what you'll respond with, but we've heard about substance abuse disorder, other mental health challenges. When we have a dual diagnosis situation, which so often is the case, do you think that addressing only one or the other in your observations tends to be effective, or do both need to be concurrently addressed?
It's my opinion, they need to be addressed.
Me too. So I wanted to ask you a little bit about something you wrote in your application as it applies to some specific situations. So when asked to characterize your views on how a judge would exercise her discretion, you wrote that all defendants accepting responsibility or having been found guilty should be afforded the ability to demonstrate mitigating circumstances or exceptions to sentencing guidelines, and give the court an opportunity to fully consider what the proper consequences of such a finding should be, which I agree with as well. When we think about making sure that a defendant is afforded the ability to demonstrate, how, as a judge, would you do that? Because we have defendants, especially younger defendants, who potentially are distrusting even of their own court-appointed attorney, and may not be forthcoming, and may even be avoiding sharing information to avoid incriminating someone else they know, for example. So how, as a judge, would you make sure that the defendant is afforded that opportunity?
So if what we're talking about is addressing drug and alcohol issues or dual diagnosis, then we always have the court clinic, and if I actually that was appropriate, I would have that person evaluated. But part of the point, if I have family members there, I have a defendant who is showing remorse, I have circumstances that have led him where he is, whether it's poverty, or it's lack of family support, or it's lack of education, or lack of opportunity. These are things that in my opinion, should be mitigating and cause us to send them for incarceration, but perhaps a community court setting or helpful.
Yeah, and you've paraphrased some of the mitigating circumstances from the Sentencing Commission, right? So I guess beyond that, like some of the other things you're talking about, their background, whether it be poverty, whether it be in a community with deep police penetration. I mean, I won't read the list, but how would you make sure, I'm hearing how you would address it, which I like. How would you make sure as a judge, straight that, do you think it would be your responsibility as a judge to probe for that information if it's not being offered?
Yes.
The second non-exclusive mitigating factor in the commission's guidelines is that the defendant is suffering a mental or physical condition that significantly reduced his culpability for the offense. So do you consider PTSD to be a mental condition that would fit that, that category? And I'm thinking of a couple of populations. I'm thinking about our incarcerated women who, in my experience, and from what I understand overwhelmingly, have backgrounds of being victim of either sexual assault or domestic violence or both. Is incarceration a traumatizing experience?
For most people, yes.
And you've had occasion to visit our houses of correction?
Many.
And so are you familiar with the fact that Donald Trump's Department of Justice has asserted that our Department of Corrections routinely violates our citizens' civil rights regarding access to mental health care?
Yes, aware of that.
And so would prior incarceration, if the circumstances of that individual's incarceration fit into the framework of the complaints that the Trump administration had, would prior incarceration and the trauma associated be part of the mitigating factors you'd consider?
Possibly. I think it's one of the factors that should be considered. I don't think it's the only factor.
And when it comes to brain development and executive functioning and impulse control, we know juveniles obviously haven't fully developed that yet. The Supreme Court of the United States has said that we treat children as constitutionally different than adults for sentencing. And the Supreme Judicial Court in Massachusetts, in Dyachenko case, noted that they looked to current scientific research on adolescent brain development in the myriad significant ways that this development impacts a juvenile's personality and behavior. My understanding of the current scientific research is that we well know that brain development impacts personality and behavior beyond the age of 18. I'm not sure the criminal justice system has caught up to that or has reckoned with it, is maybe the better way to put it. Do you think youthfulness, and I don't mean as a juvenile, but, and I'm not too concerned where you put the cutoff, but 19, 20, 21, 22, is that a mitigating factor in itself?
Yes. And in fact, in South Africa, I think that the juvenile or the youth cutoff based on the brain development science is 35. So really, in America, we're lagging behind in understanding and incorporating that into our system.
It seems to me there's a legal framework where bringing in more of this evidence would potentially impact individual defendants. So I hope that that does develop, and perhaps if you're on the bench, you see it develop. Well, actually, I'm going to leave it at that. Thank you.
Councilor Jubinville.
Thank you, Councilor Kennedy. Good afternoon. A while since I've seen you, too. Let me ask you, do they still have the Justinian picnic?
They do, and how come you haven't?
I don't know, but that was the greatest picnic I ever went to. When it was up in Danvers.
I'm
Incredible.
She's coming this year as well.
Still the same as it was?
Yes, it's no longer at that site. It's now in training at Thompson's. Still fun.
Councilor Depalo and I are offended that they're getting an invitation.
We'll crash. Councilor Kennedy.
All are welcome. All are welcome. I think I remember it. In any event, I've known you a long time, and I think you're a wonderful candidate. Great. I missed Judge Agnes's talk on your behalf, but I admire him a great deal. He's one of the finest judges I've ever known. So you got that going for you. And the other thing is, very quickly, are you familiar with the case of Commonwealth versus Gibo? Gibo, G-E-B-O. Okay, that's a case on whether a defendant can waive a right to a jury and when he can waive it. It stems from a case in Western Mass where a defendant was scheduled for trial, and on the day he informed the judge that he would be jury waiving it. And the judge said, "You're going to have to give me compelling evidence to be able to waive that." And he objected and indicated to the judge that he didn't think he had to produce anything by way of proving it. It's a choice of the defendant. So Gibo outlines that case and says that absolutely a defendant has a right up in time of impanelment to request it. Doesn't have to prove anything to the judge, just ask for it. So that being said, I see judges as last week I saw a judge in a courtroom and he said to the parties, "Are you picking a trial? It's going to be a bench trial or a jury trial?" The lawyer said, "It's going to be a bench trial." He said, "Okay, so I'm going to pick a date." And he said, "I want the waiver now." So had that been my case, I would have said to him, the judge, that the Supreme Judicial Court, all 7 members have said in a public hearing at this council that for any lawyer to waive that very important right before knowing where a judge is sitting would be committing malpractice and ineffective assistance of counsel. So, notwithstanding judges still wanting that waiver done before you even know who's going to be sitting on the case when you come back, I think is wrong. The bigger question is, what are you going to do if faced with that issue?
It's always my opinion that a jury should be available to a defendant regardless. I would not require a waiver to be signed at that time of scheduling, although I understand the court needs to be able to know what numbers they have in terms of how many jury cases. But it seems to me if the defendant appeared on the day of trial and wanted a jury, I think we owe that to the defendant.
Well, the other issue for me is when I'm asked, are you going to have a jury waive trial? I go, I'm asking for a trial. Whether it will be jury waived or jury will be determined on the day I show up for that trial. You wouldn't have any objection to the lawyer saying that to you, right?
No, I would not.
Beautiful. So you would be what us lawyers have termed, you would be on the list.
Well, you don't talk about the list.
Well, it's an important issue to me, and I think it's sad when I hear lawyers saying to me, I would never jury waive in front of this judge. I go, geez, that's a terrible moniker to throw on a judge. And why would you want that if you were a judge, that people don't trust you enough to jury waive with you? So luckily, it's only a small percentage of judges. But other than shooting my mouth off about that, I don't have anything else. I'm going to be glad to vote for you next week. And it's glad to see you again. You're a wonderful judge.
I think you're the first person to have a dog as a witness in the history of the Commonwealth.
I was going to bring my dog, but
I've obviously known you forever, and you have an incredible amount of respect for you, and I'm really happy you're here. I'll be voting for you next year.
Thank you.